How was the test? Every time I ask the same question, every time you guys smile and bend your head. Okay. How many of you answered 50 questions? 45 plus 40, 35, 30, 20s, 15s, below 15. Okay. So we'll start. With reference to the safeguards provided to the members of All India Service under the Constitution, consider the following statements. How many of you answered this? Okay. Members of All India Services hold office during the pleasure of President. He is appointed by them, so they hold office until their. Members of All India Service cannot be dismissed by an authority subordinate to them. That is correct. So both are correct. Next, second question, how many of you answered? Okay, fairly good. What is the answer? Okay. Which of the following statements with reference to district planning committee are correct? One only. Okay. Then any other answer? D, neither. Then any other answer? See, there are certain keywords for you have to look in this here. First statement is Constitution of India mandates that DPC shall be constituted in the district level in every state. District Planning Committee. All the members of DPC are elected by the elected members of Panchayat and Municipality at district level. What was the issue with the second statement? All members and see, one thing is your Panchayat and Municipality 73rd, 74th amendment when it was brought about, it was to create a uniformity. Yes or no? In the municipality levels also, there are certain tiers. For example, if you have to have Panchayat, we can have either 3 level or 2 levels. Yes, the intermediate level is a buffer level based on population. If you have to have 3rd level, then you have to have DPC. Then there is a mandate because Panchayat should be created in all of the places. And second statement is all the members of DPC, your assumption was correct, but here it is not Panchayat and Municipality, the number is as determined as that respective state legislature. So only one is correct, A1 only. Third statement. Third question, which one of the following statements with reference to Lok Adalat is or are correct? How many of you answered this? Okay, what is the answer? C. Okay. Again, here look for the wordings. Lok Adalat have the power to deal with cases which are at pre-litigation stage. That is correct. That is the whole point of Lok Adalat. Lok Adalat have no jurisdiction to deal with criminal cases. Very happily would have marked it is wrong. Here is where you have to differentiate criminal cases. Pe compoundable are there, non-compoundable are there. Severe heinous crimes will not be coming in. So they have the jurisdiction over criminal cases, but over non-compoundable criminal cases they have no jurisdiction. They have jurisdiction over compoundable criminal cases. Okay. So second one is wrong. Third one, an appeal against decision of Lok Adalat generally lies before the concerned High Court. No, Lok Adalat ka appeal is not like that, it is permanent and binding. So option is A1 only. Next, fourth one. Which of the following constitutional office is debarred from any further appointment? What is it? Debarred from appointment under Government of India or a state government after ceasing to hold office. Election Commissioner, Chairman of State Public Service Commission, CAG, Attorney General of India. State?
They can go for UPSC.
Exactly. The only answer is CAG. See, your election commissioners can become the chairman of election commission. Your state election commission can go for your UPSC. Your attorney general, that guy though, it is not even a permanent job. So obviously he can even do private itself. Why won't he be able to do further? The only person who can't do here is CAG. Correct answer is C, CAG. Okay. Next, fifth one, consider the following institution: Rajya Sabha, State Legislative Assembly, State Legislative Council, Office of President, Office of Vice President. The Election Commission of India is vested with the authority to conduct elections for how many of this? All five. Everyone has written the same thing. No, this is very static, very basic question. Next, sixth one. With reference to the 9th schedule of the Constitution of India, consider the following statements. How many of you have answered this? Okay, fair enough. Laws placed under 9th schedule enjoy immunity from judicial review even if they violate basic structure. Now that itself is a giveaway. No, basic structure concept is not there, especially it was told after IR Coelho case. First statement is wrong. A law can be included in the 9th schedule only through a constitutional amendment under Article 368. This is correct. So option B, 2 only. Next, consider the following statements with reference to the provisions related to cooperative societies under Constitution of India. How many of you answered this? This is also straightforward enough. First two statements are correct. Third statement pe union list it is written, it is under state list. So option is A, 1 and 2 only. Eighth question, how many of you have answered? What is the answer? Excellent, neither 1 nor 2. The provision of 9A do not apply to union territories. Why won't it apply to union territories? It will apply to union territories. The provisions of 9A apply to schedule area under 5th schedule. No, it does not apply. Okay. So it is neither 1 nor 2. Ninth question. With reference to the Goods and Service Tax Council, consider the following statements. GST Council is an extra constitutional body. Is it an extra constitutional body? It is a constitutional body. So first statement is wrong. The Union Finance Minister acts as a chairperson of the council. Correct, it is GST Council. Next, every decision of the council is to be taken by a majority of not less than 2/3 of the weighted votes. No, 3/4 of the weighted votes. So correct option is C, 2 only. Okay. 10th question, how many of you answered? Okay. So what is the answer for 10th one? Excellent, A, 1 and 2 only. They are generally established for every panchayat. They have authority to try both civil and criminal cases. Every judgment of Gram Nyayalaya is final and binding with no provision for appeal. No. Your criminal cases can go to appeal for your sessions court, civil cases can go to appeal for district courts. So option is A, 1 and 2 only. 11th one, option is 2 only. With reference to PIL, consider the following statement. Principle of locus standi applies while filing a PIL. Locus standi means affected person only should file. PIL is anyone can file. So locus standi will not apply for PIL. Second statement is correct. PIL may be filed only for enforcement or all those things. Third, PIL can be filed only in Supreme Court. There is no such thing. Supreme Court or High Court also. So option is B, 2 only. 12th one, it is direct, straightforward, static question. How many of you answered this? Why others didn't answer? This is direct, straightforward. Okay. The audit report on finance accounts. The audit report on finance committee submitted by CAG to President is examined by which parliamentary committee? It is PSC, Public Account Committee. That is why it is called as friend, philosopher and guide of PSC. Next, 12th one, 13th one. Consider the following state commissions. How many of you answered this? National Commission, they are asking, look at the question here, which of the above commissions have been mentioned under original Constitution of India as enacted by Constituent Assembly? 1950 pe, which of these bodies were there, they are asking. National Commission for Scheduled Tribes, was it there? They asked Special Officer for SC/ST was there. There was no such commission. So, first one is wrong. National Commission for Backward Class, this was your 102nd constitutional amendment. This was not there. Special Officer for Linguistic Minorities. Linguistic minorities came only after state reorganization came in 1956. So, 1950 by it being present is not possible. National Commission for Women is not at all a constitutional body, it is a statutory body. So, none of the above, D. Okay. Next, 14th one. With reference to Union Territories of India and their representation in Parliament, consider the following statements. How many of you answered this? Okay, what is the answer? Okay. The Constitution empowers Parliament to prescribe the manner for choosing members of Rajya Sabha from Union Territories. The answer is correct. Yes. Parliament may alter the number and boundaries of Union Territories by law without the requirement of constitutional amendment. Yes, this is the anything with respect to territory, it will come under your simple only. So, it does not have to be a constitutional amendment. Next, every Union Territory has a legislative assembly, has been allocated seats in Rajya Sabha. That is also true. Yes, all three are correct. If you want, you write this down. Delhi has 3 seats which has been allocated. Puducherry has 1 seat. Puducherry has 1 seat. Jammu and Kashmir has 4 seats. But the important thing here is it is still vacant because Election Commission of India has not yet conducted the elections. So, option is C, all 3.
JNK has 4 seats.
Yes. But it is vacant, all 4 are vacant. Next, 15th question. Which of the following statements regarding PISA Act is correct? How many of you answered this? Okay. The Act is applicable to both 5th and 6th schedule areas. No, it is only applicable to 5th schedule areas. Second statement, the prior recommendation of Gram Sabha is mandatory for grant of concession for the exploitation of any mineral in the schedule area. Statement is wrong. They just used word play. The prior recommendation of Gram Sabha is mandatory for grant of concession of exploitation of everything is fine. The only issue here is any minerals. It is only applicable for minor minerals. There are minerals by minor minerals, major minerals. Gram Sabha recommendation is needed for only minor minerals, not any mineral or major mineral. Okay, so that was the issue there. Under the Act, it is mandatory to reserve all seats of chairpersons to Panchayat all levels for scheduled tribes. This is correct. So, correct option is B3 only. Sixteenth question. How many of you answered this? This is straightforward, static question only. 16th, consider the following statements with respect to Central Vigilance Commission. CVC was a non-statutory body originally conferred in 2003, correct. CVC members are appointed by President on recommendation, that is also correct. Third, CVC comes under administrative control of Ministry of Home Affairs. This would be entirely opposite to the purpose of bringing CVC if you put it under Home Ministry. It is an independent body.
I out of hand removed it because usually ministry is always not.
Ministries. Okay. Correct option is B, only 2. Which are that? 1 and 2 are correct. Third one is wrong. 17. Which of the following constitute duties of interstate council as established under 263 of the Constitution? How many answered this? Oh, with just the option, even if you don't know, you can answer this easily. Yes. Answer is C, only 3. Inquiring into advising upon your Interstate dispute is correct, that is the whole point, it is there. Investing subjects where states and union have common interest, that is correct. Adjudicating interstate water dispute, then yeah, why do we need a committee for that, separate committee? So, third one is wrong. Fourth one, making a recommendation, is correct. So, 17 answer is C only 3. 18, which of the following oh, it's 9:54, by this pace if I go I think it will take more than, I will keep telling the options, okay, wherever you have issue you tell me. 18, which one of the following category persons are entitled to get free legal aid under provisions of Legal Service Authority? How many of you answered this? C, 1, 2, 3. Member of OBC is not applicable under your free legal aid. Okay.
10 lakh is like, quite a good.
Actually, they have to make it a little bit lesser number, but for women, na, with the recent changes that they have brought, okay, 10 lakh will come also. And here they are not just giving it not only for income status, they are also giving it based on the gender. Okay, 19, it is A, 1 and 2 only. The third statement is wrong. Assigning to Panchayat the taxes, the duties, tolls and fees levied and collected by the state government. No, they allow them only to collect. 20th option is C, both 1 and 2 are correct. Okay. #21, this is again direct only, but it is just current affair. Only one, consider the following union territory. How many of the union territory have its own legislative assembly and high court? Legislative assembly to everyone has, but high court only Delhi has. Okay, Puducherry doesn't have, Chandigarh doesn't have. Okay, 22, D. Hello. Good morning. Actually, I am in test discussion right now. I will call you later. Statement 1. Election Commission of India is empowered to address and decide upon all doubts, disputes concerning election of president. Wrong. Second statement, under Article 324 of the Constitution, Election Commission of India is entrusted with responsibility of conducting presidential election. Correct. So, option is D. Statement 1 is incorrect. Statement 2 is correct. Next is 23rd. 23rd is D, neither 1 nor 2. Statement 1 it is not Manipur, it is Mizoram. Statement 2 is all members of district councils for autonomous regions are elected by adult suffrage. No, some are nominated by your governor and remaining are by your universal adult franchise. 24. All three are correct. Okay, 24 is C. 25 is A, 1 only. The second statement, chairperson of UPSC can only be removed from office. See, can only be removed from office on the same grounds and in the same manner Supreme Court judge. If it is proved misbehavior or incapacity, then only. If he is insolvent, if he is of unsound mind and body, president can remove him. It does not have to follow the same procedure as that of your Supreme Court judge. Okay, so this is the issue here. Only.
But it says same grounds, not same procedure.
No, same grounds also. Supreme Court judge is not removed on exactly same grounds as UPSC. UPSC is additional grounds. If in case he has interests outside Government of India to match his personal interest also he does, but that is not there for Supreme Court. So, only is the issue here. 26A, both statement 1 and 2 are correct. Okay. 26A.
Does not explain.
Consider the following statements. CBI must obtain the consent of the state concerned before beginning the investigation of a crime in a state. Yes, that is what is in the name of your general consent.
Yeah, so but see, the second statement does not explain statement 1.
CBI is governed by Delhi Special Police Establishment Act of 1946. In this act, it tells that only. So that is why we are telling it explains it. 27th is reference to appointment of district judges. A1 only is correct. Second statement tells that eligible to be a district judge only if he has been advocate or pleader for not less than 10 years. It is 7 years. 28. Which of the following is not a constitutional body? It is B. NHRC, National Human Rights Commission. C, both 1 and 2. B 1 and 2 only. The minimum age to be a person of a member of Gram Sabha is 21 years. No, to contest election is you need 21 years. To be a member of Gram Sabha, you just have to be citizen, which will be at 18 years. 31. Both 1 and 2. 32. D. Chairman of Bar Council of India is appointed by the President of India is not correct. Bar Council. 33. 1 and 3 only. He can only be removed by the President on the recommendation of Union Cabinet. No, it is on the same grounds as that if you are Supreme Court. 34. 34 is D, neither 1 nor 2. See, the power of High Court to issue writs is derived from Part 3 of the Constitution. Article 32, Supreme Court gets it there. Your High Court is Article 226. So, first statement is wrong. They further, Parliament put it to High Court. Originally, Constitution put it only for your Supreme Court. Otherwise, you know the statement, if at all, if a fundamental right violation comes to High Court can even reject that case. But Supreme Court cannot reject that case is because Part 3 provision is given to Supreme Court. It was extended to High Court. So, second, High Court has the power to issue habeas corpus, mandamus, certiorari prohibition, but not cure warrant. No, it can issue cure warrant also. So, that is also wrong. Answer is D, neither 1 nor 2. Next, 35. D, 1, 2 and 3. Next, 36. A, 1 only. Which of the following matters are dealt with under RPA Act of 1950? Allocation of seats in the House of People and delimitation constituency is there. Manner of election of President of India. No, that is not mentioned in here. It is mentioned according to President and Vice President Elections Act of 1952. Disqualification of members in Parliament on the grounds of RPA 51 and not 50. Next, 37. 37 is C2 only. The strength of Election Commission of India is determined by Parliament. No, on behalf of Parliament, it is done by President. So, first one is wrong. Next, third, in case of difference of opinion among the Chief Election Commissioner and other election commissioners, CEC has a casting vote. No casting vote, it is only decided based on majority. So, 1 and 3 are wrong, only 2 is correct. C2 is the answer. Next, 38. 38 B, 1 and 2 only. States must reserve at least 1/3. It is a voluntary provision. They are not restricted to only 1/3. They can make any number of reservations, percentage. 39.
Ma'am, but it says at least reserve 1/3.
No, that is what I am telling. It is not that they are bound by any number. They can go for any extent. It is a voluntary provision for them. No, what I am telling is they can increase or decrease the limits.
They said one
No, I
third is
got minimum it
it
is.
is minimum.
Ha,
So
ha.
after that, any amount that is up to the state.
Yes.
So here also the statement only says that
At least 1/3, I know it almost looks like minimum to 1/3 you have to give, but here what they have mentioned in the act is it is a voluntary provision. These people have adopted 1/3, okay, but it is not mandatory for them to do 1/3. Next is 39. 39 is B. 40th. A one only option. First statement is correct. Attorney General ka term is not fixed by Constitution. He holds office during pleasure of President. Constitution mandates that Attorney General must resign. No, he resigns out of convention. He doesn't resign because Council of Ministers resign, and there is no such thing that states he has to resign. Next is 41. 41, both 1 and 2 are correct.
he is prohibited from engaging in private legal practice.
Where is it?
It is wrong.
Yeah, it is wrong. 41. With reference to Constitution of India, consider the following statements. Union Council of Ministers hold office during pleasure of President. Resignation of Council of Ministers in state does not necessarily lead to President's rule. Both are correct. 42. A1 only. With
Ma'am, it does require constitutional amendment because resolution from the Rajya Sabha is needed, but then after that constitutional amendment would be needed to create the commission, right?
no, see, what they are asking is with reference to Constitution of India, consider the following statements. The creation of an all India judicial service does not require a constitutional amendment under Article 368. All India judicial service is somewhere like your IAS, IPS, IFS.
Yeah.
The first main thing you need is your Rajya Sabha to pass the resolution, but it won't be considered as a constitutional amendment. To make that happen, it should not be considered as a constitutional amendment. Second statement, constitutional amendment bills can be introduced in either house of parliament, but prior approval of president is required. No, it is only the lower house. 43rd.
41 is A.
41 is C.
42 is A.
Huh. 43 is D. 43 is D. 44. It is only Gram Sabha. B. Next. 45. 45 is A1 only. Okay. Next 46. This is also pretty straightforward. C. Because he has 6 months of time. 47 D. 47 D. 1, 2 and 3. What happened? 47. With reference to the Advocate General for the state, consider the following statements. He is appointed by the President of India on the recommendation of Governor of the concerned state. That is there. In the performance of his duties, he shall have the right of audience in all courts in the territory of India. Actually, this statement you would have read it as in the territory of state, right? But in case if that particular state ka issue comes up in the center, that is in your India Supreme Court, then he has the right to audience there also. Remember, you would have read this statement. He has only in the territory of state unless the particular case comes up in the center, that is in your Supreme Court, then he has the right of audience there also.
It would be the case wherever the case is going on and the state needs representation, he will be representing the state.
No, if the state has some case which it has come up with the center, let's say center and state conflict only has come up, then he has the right to audience. Okay, let's say it's in Supreme Court. He doesn't need permission to go sit because it is his state, he can go sit.
No, that is what I was saying. Because it's state to conflict is there and it goes to the Supreme Court,
Yes.
then he
Yes,
still be
yes.
allowed to represent, right?
Yes. Next, 48.
I was confused between A and B in this.
Okay, the third option. 48D, 2001 census. D. (49). How many of you answered this? This is very basic question. 49 is B, certiorari. Last 50th one, it is C, only 3. Statement 1 is correct. Lok Adalat is not empowered to handle non-compoundable offences. Second statement, Lok Adalat is not empowered to handle cases of pre-litigation status. That is the whole point, Lok Adalat is there. So, that statement is wrong. There is no court fee payable when a matter is filed in a Lok Adalat. Third statement is correct. Lok Adalat is not empowered to handle matters relating to divorce. This is correct. Okay. So, option is C, only 3. Okay. Clear up until here? Any doubts?